Today is December 26, 2022. It's about 12 o'clock high noon, and therefore we still can feel the Christmas celebration yesterday. I am with you now to reload my suggested bar examination answers to criminal law, which I already originally uploaded, except my guardian angel was trying to tell me something must have gone wrong with the way I answered the issue of rape and sexual assault. And good enough, I visited again the Supreme Court decisions because I was using the case of People versus Bangayan, when actually just a few I guess months after that, Justice Diosdado Peralta took an opportunity to discuss in an integrated manner the issue of rape and sexual assault under the case of People versus Tulagan. My little shortfall there is that in the case of People versus Bangayan, where you have a girl who is over 12 years old, who was having a real intimate love affair, including consummation of the sexual act, with a man a little older than her. It is the brother of her brother-in-law. And later on, when the Supreme Court reviewed it, the initial impression of the trial court that there was incestuous rape was disproven because if you have a dealing with your brother-in-law sexually, then probably it would meet the criterion on incestuous rape somehow. But here, the brother-in-law has a brother, and it was this younger brother who was having a relationship with this girl over 12 but below 18. And their affair continued until they finally got two children. At a certain point in the story, the love story of these two, the parents or the grandparents apparently of the girl filed a case of statutory rape, and so that therefore the case went into the situation, and the decision of the Supreme Court, penned by no less than retired Justice Rosemary Carandang, brought up the matter that if the girl is over 12 but below 18, then there is no statutory rape. But the more beautiful thing is when the girl who's 12 years old consented to the relationship. There is not even a criminal case against the man who got involved with her. And so I got carried away with that very beautiful concept. And so in the problem on rape in the 2022, November 2022 bar exams, I said that the woman who had, I think, oral sex with a girl who is over 12 and therefore gave consent, that there is a little element that I had to contend with. That the girl apparently was paid. And so I had to review. This time I bumped into the case of People versus Tulagan, where Justice Peralta introduced the concept that if there is consent given by a girl, supposedly victim, over 12, but the victim was enthused to accept money, then there will still be sexual assault, even if she gave her consent. Because the consent is obvious because of the money. But without the money, the case of Bangayan would still be prevailing. And so these are very new slants in the matter of rape. And so we will talk about this now because I withdrew my original load and that is the only change. The others remain the same, but I can no longer identically repeat myself on my commentaries in the rest of the slides. So let us now move on to again revisit my suggested answers on criminal law in the November 2022 bar examination. As I was saying, there were a number of modules from which the bar questions were taken. And this slide now, which I missed in the first upload, would enumerate the number of problems that were given in each of the modules. In the crimes against persons, there were 2 questions that were posted. Felonies took a lot of questions, about 8 of them, and they are very interesting. In the case of chastity and child abuse, and this is where we will touch base on the case that I was mentioning a while ago, there were 2 problems given. In prohibited drugs, there is one interesting case where what was caught was a syringe. And there was failure of the prosecution to prove that the syringe had been used for using prohibited drugs. Just because it is a syringe, the presumption that it was used for prohibited drugs was fatal to the prosecution that the case was dismissed. We'll talk about that. And because it was given as a problem. And then on cybercrime, there is a case here of cyberlibel. And finally, GRAFT and corruption in the matter of procurement, which happened somewhere in Mindanao. Moving now to the problems on persons. The first problem on persons has to do with homicide, and that's problem number 1, involving self-defense. The problem reads, Police Officer John ran after Randy, who had just killed Willie, in John's presence. John fired at Randy in an attempt to stop him in his tracks. In response, Randy fired back at John, hitting him. John was seriously wounded but survived due to timely medical assistance. Randy was then charged with frustrated homicide. During the trial, Randy claimed self-defense. Is Randy's claim of self-defense tenable? Explain briefly. Our suggested answer. No, Randy's self-defense is not tenable. The requirements to invoke self-defense are, first, unlawful aggression. Police Officer John did not commit unlawful aggression versus Randy because he was just doing his lawful duty. Second, reasonable necessity of the means employed to prevent or repel the aggression. The shooting of Randy at an arresting police officer, is not a reasonable means to defend himself after committing a felony. He should have surrendered himself to John. And the third element for self-defense is that there was no provocation. In fact, Randy provoked Police John in killing Willie in the officer's presence for John to perform his lawful duty to arrest Randy. And so this was lifted from 2 cases. A later one, Cabanlig versus Andigan Bayan in July 28, 2005, and earlier, Pipor versus De Lima in 1922. This little circle here says JSB number 19, page 7. It means that when I gave my tips to my bar candidates, there was page 7, and it was not, this particular problem was included as number 19. Nahulaan po natin na lalabas itong problem na ito on self-defense. Second slide on persons. Again, homicide, this time involving the aggravating qualifying circumstance of treachery. This one very interesting, and some of us who may have some impressions on the suddenness of the attack may have to revisit the concept here. The problem reads, Moe, Curly, and Larry were drinking and singing inside the karaoke bar when suddenly Buboy entered the bar and without warning immediately shot all three of them using a caliber .45 pistol. Thereafter, Buboy ran out of the bar to escape. Moe, Curly, and Larry died instantly due to gunshot wounds in their heads and bodies. With the help of eyewitnesses, Buboy was arrested. After inquest, the prosecutor charged Buboy with 3 counts of homicide. Do you agree with the charge of homicide against Buboy? Explain briefly. This one, for the bar candidates, what can be very confusing is the suddenness, without warning, immediate the 3 of them, which will somehow invite an impression of treachery. But let's find out how the Supreme Court decided in the case of People versus Consa, a 2003 decision. My answer, do you agree with the charge of homicide against Buboy? I said, I agree that Buboy is to be charged with homicide. He did not commit murder. There was no treachery as a qualifying aggravating circumstance. Buboy did not plan his shooting to intentionally place the victims where they had no chance to fight or retreat. Buboy's shooting was not designed to make it impossible or hard for them to defend themselves or to retaliate. Here, the Supreme Court now introduces a new concept where if treachery is invoked as a qualifying aggravating circumstance to make the killing murder, it is not only the killing should not only be something that was perceived, like in even premeditation. The treachery itself should have been intentionally introduced in the planning and the execution of the killing. If, like in this case, he just barged into the karaoke bar and started shooting, the suddenness of the attack would not qualify as treachery if and when Buboy did not plan that kind of treachery. It has to be part of his plan, and that was not proven by the prosecution. So those are the 2 problems on persons, and we are now ready with the second module on felonies, where you have 8 problems given here. The first problem under felonies has something to do with praeter intentionem versus the defense of accident. Michael was driving along the highway when he executed a prohibited U-turn. Towards a police officer accosted Michael for the traffic violation. A verbal argument ensued between them. Doerge suddenly drew his service firearm and pointed it at Michael. Doerge ordered Michael to alight from his car, which the latter obeyed. Doerge then handcuffed Michael and pinned his head and body against the pavement until he could no longer breathe. Michael died. Charged with homicide, George interposed the exempting circumstance of accident as a defense. Yung praeter intentionem. Wala siyang intention talagang patayin, pero napatay. If you were the judge, how would you resolve Doid's defense? Explain briefly. Our suggested answer. As the judge, I would proceed with Doid's prosecution because his exempting circumstance of accident cannot be valid. The required circumstance in accident and in relation to attending facts are runs like this. Number one, the first required circumstance is that the person making the defense was performing a lawful act. If we revisit the case facts, George did not perform a lawful act of drawing his firearm. He could just have issued a traffic citation versus Michael for the prohibited U-turn violation. Take note that all of this commotion started when Michael took a U-turn. Well, the U-turn, while it is a violation of a traffic rule, no, would probably not amount to imprisonment. And you know, when somebody violates a traffic rule and you're a police officer authorized to exercise traffic implementation, the easiest way for you is to issue a traffic citation ticket. Not to let this guy say, "Hey, go down," at tapos you point the gun at the person. That pointing the gun at the person, no, drawing your firearm is unlawful. It's not a lawful act. The lawful act is to issue a traffic citation. Number two, the performance of the act is with due care. Due care was absent for George to point the gun at Michael, handcuff him to pin his head and body to the pavement. Nasaan ang due care dun? Diba? Di man lumalaban yung tao, then you point the gun and then you even handcuff him, you know. And what did he commit? Just a violation of no U-turn signal. Number three, causes injury by mere accident. George's act of pointing the gun, ordering Michael to alight from the car, his being handcuffed to pin his head and body to the pavement were deliberate acts and not fortuitous events. So number four, there was no fault or intention of causing the injury. Sure, but in criminal law, Michael's death is presumed to be with intent to kill. We know that, you know. And so that therefore, the act of killing Michael would be already very heavy against the arresting officer Michael, no? George rather. Okay. So this was taken from the case of Wakoy versus People, a June 22, 2015 case, and another one, even the later one, Nieva versus People, and November 16, 2016 case. Again, a little advertisement. This was tip number 6 on page 5 when I which I gave to my bar candidates at the University of Manila. The second problem under felonies on participation is conspiracy and evident premeditation. This is very interesting. Bernardo, that was problem number 4 in the bar, a mayoralty candidate of Osram City, wanted to eliminate Yori, his political opponent. Yori announced his intention to run for mayor of the same city. A month before the filing of candidacy, Bernardo and Benjamin met at a hotel and discussed their plan to kill Yori on the day when he would file a certificate of candidacy. Based on the agreement, Bernardo would provide the guns and the money, while Benjamin would provide the personnel to cordon off all roads leading to the COMELEC's local office. On the day of the execution of the plan, however, Benjamin flew to Manila to avoid being involved in the planned killing of Yori. Bernardo, determined to kill Yori, convened his own armed group and laid out a new plan to kill Yori. And in accordance with it, his armed group patrolled all the roads leading to the COMELEC's local office. Bernardo remained in his house and monitored the execution of the plan from there. As soon as Yori and his supporters passed by the main road at around 2 p.m., Bernardo's armed group opened fire at them. Yori was unharmed as he was inside a bulletproof vehicle. But 10 of his supporters were killed. Bernardo, the members of his armed group, and Benjamin were later charged with 10 counts of murder for the death of Fiori's supporters and 1 count of attempted murder of Fiori. Discuss the criminal liability for the crimes charged against each of the following: 1. Bernardo, 2. Members of Bernardo's armed group, and 3. Benjamin. Explain briefly. Our suggested answer: tabulating the accused and his criminal liability, the first one is Bernardo. Bernardo is principal by inducement. For murder, 10 counts, and attempted murder, 1 count. No? With a qualifying, aggravating circumstances of evident premeditation. Committed in conspiracy with a band of more than 3 assailants. So that is the criminal liability that we are imposing on Bernardo. On the third 10 armed men, they are principals by direct participation for murder, 10 counts, and attempted murder, 1 count. Committed in conspiracy with a band of more than 3 assailants, with the qualifying aggravating circumstance of evident premeditation with the new plan. You notice after the plan between Benjamin and Bernardo could not be executed because Benjamin decided not to join, they again, Bernardo gathered his group and set up here a new plan to kill. So there was still planning, before they finally executed that. And so that therefore, the concept of evident premeditation, not probably as long as the period between Benjamin and Bernardo, but true enough, there was still time for the 10 together with Bernardo to figure out what they will do. And therefore, there is evident premeditation. So they would have essentially the same aggravating qualifying circumstance, except that Bernardo would have 2 counts of evident premeditation, the one with with Benjamin, the other one with the term armed men. In the case of Benjamin, there is no criminal liability for not participating in the execution of the offense. He's sitting down to discuss, could have led him to be a principal by inducement. But he decided, which is exactly the concept that in evident premeditation, there has to be a time gap to allow every participant in the planning not to participate and therefore be free of criminal liability. That's exactly the situation with Benjamin. This was taken in the case of People versus Beralta, a case of October 29, 1968. The third problem on felonies has something to do with the stages of execution: consummated versus attempted parricide. This is problem number 5 in the bar exams, and it reads: a police officer responded to a disturbance call at around 1:30 p.m. in an apartment in Quezon City. Upon his arrival, the police officer encountered Sisa stabbing her 1-year-old child with a kitchen knife. The police officer grabbed Sisa and the latter threw the knife on the floor. Sisa was immediately taken into custody. Despite suffering multiple stab wounds on her back, the child survived. During the trial, Sisa insisted that she can only be held liable for attempted parricide because she voluntarily desisted when she threw down the knife. Is Sisa's contention tenable? Explain briefly. This is very interesting and you need to be very sharp into the events. Our suggested answer: no. Sisa's contention is not tenable. The first stab wound completed the elements of execution. Take note here, when the police officer arrived, Sisa was already stabbing her 1-year-old child. As a matter of fact, the child suffered multiple stab wounds. but it did not die. And so the first stab wound completed the elements of execution, but frustrated homicide was the offense committed because the child did not die for a cause independent of the offending mother's will. No, it is the arrival of the well no, actually consummated, hindi lang natuluyan kaya frustrated. Without the mother throwing the knife, that could have started another process of parricide, mo second event ng parricide, different from the initial frustrated offense. So there can be in effect two frustrated parricide before the police arrived, and when he already came, he saw the frustrated homicide, almost consummated, hindi lang namatay. Then there could have been a second attempted. Kaya lang itinapon yung kutsilyo. No? So this is the case of Valenzuela versus People, a June 21, 2000 case lifted from Article 6 of the Revised Penal Code. Again, this was given as problem number 8 or tip number 8 on page 7 when I reviewed this with my bar candidates. The fourth problem on felonies, and that is problem number 6, has something to do with a complex crime involving robbery with homicide. A complex crime enumerated in the Revised Penal Code. The problem reads, Ana and Barbara, while working inside their sari-sari store, saw Javier and George robbing an elderly woman of her purse and brutally beating her to death. Ana and Barbara immediately ran outside, and when they tried to help the elderly woman, Javier and George stabbed both of them. Thereafter, Javier and George ran away with the elderly woman's purse. Ana suffered one stab wound which punctured her lung, but she survived due to timely medical assistance. Barbara, however, died as a result of 9 stab wounds, one of which pierced her spleen. If you were the prosecutor, what crime or crimes will you file against Javier and George for the death of the elderly woman, the death of Barbara, and the injuries sustained by Ana? Explain briefly. As the prosecutor, I shall file one information for the complex crime of robbery with homicide. Robbery with homicide. And the elements of the robbery of the homicide will be for the early woman's death, homicide for 1 count. For the death of Barbara, homicide for the 2nd count. And for Ana, frustrated homicide. In a special complex crime of robbery with homicide, the offense is an individual felony. That's why I'm only filing one information with specific penalty in the Revised Penal Code. It includes the elements of the consummated homicide on 2 counts, this one, and the frustrated homicide, all included in the information where there is robbery. So it's a complex crime of robbery with homicide with the following details. This is taken from Article 294, Paragraph 1 of the Revised Penal Code and demonstrated in People versus Casabuena, which happened on June 23, 2020. This is relatively new. The next problem in felony is problem number 7. Again, complex crime. There were a number of complex crimes that were introduced and, proudly favorite of the bar examiner, which is interesting. And the complex crime this time involves murder and the unlawful possession of unlicensed firearm used in the murder. And so this is very, very thick list. Let's take a look. Jesusa, a mayoralty candidate for the municipality of Jaén, Nueva Ecija, during the 2019 local elections, was ambushed and gunned down by Judas, a gun for hire. Judas was arrested at the Comelec checkpoint just after the incident. The firearm he used, a baby Armalite, was verified to be without any license. During the interrogation, Judas admitted that Poncio, the rival mayoralty candidate of Jesusa paid him 1 million to assassinate Jesusa. Due to Judas' admission, coupled with the sworn statement of an eyewitness, the prosecutor filed two information, one for murder and one for illegal possession of firearm against both Judas and Poncio. Do you agree with the prosecutor's charges against Judas and Poncio? My suggested answer, yes. I agree with the prosecutor's information for murder with price or consideration as the qualifying aggravating circumstance. Then, another information for the offense of illegal possession of an unlicensed firearm, aggravated but by its use in committing murder. The illegal possession case does not absorb the offense of murder, nor murder absorb the legal possession offense. The two offenses must be prosecuted separately. They are not in the revised penal code as complex crime. And so you have to file it separately. And this is the decision of the Supreme Court in People versus Scaling, a May 8, 1992 decision. This time in felonies, we are confronted with an impossible crime arising from a stolen, unfunded check. And this was problem number 8 in the bar exams. Jenny obtained a fire insurance from YG Insurance Company. In payment of the policy, she issued a post-dated check payable to cash in the amount of $15,000, which was handed to Lisa, YG's sales agent. Lisa did not remit the check to YG. Instead, Lisa deposited it in her husband's bank account, but the check was dishonored for having been drawn from a closed account. What crime, if any, was committed by Lisa, and if there was any, what is its prescribed penalty? Our suggested answer. Lisa committed an impossible crime punishable with 6 months of arresto mayor. Lisa performed the acts to consummate qualified theft, a crime against property. And it is qualified because she's an employee and therefore trusted to handle these collections. Her unlawful taking the check for megafoam is her intent to gain or be unjustly enriched. She would have received the value of the check, which was not hers, if it did not bounce. The unfunded check prevented the theft. Said check Lisa unlawfully took turned out to be worthless. That's why she committed a qualified theft, but it did not result to qualified theft because the money was not there. So it became an impossible crime. Under Articles 4, Paragraph 2 and 59 of the Revised Penal Code, and cited in the case of Jacinto versus People of July 13, 2009, and earlier in the case of Intod versus Court of Appeals of October 21, 1992. I was able to guess this as problem tip number 7 on page 6 of my notes. There is a requirement on preparing an information for bouncing check under BP 22. I would just like to beg your indulgence. I did not prepare this anymore because it is more of just giving an example for the form. So let's move on to the next case. This is the last problem in the bar examination, problem number 11, involving felonies. Again, another complex crime. This one is reckless imprudence resulting to homicide, serious physical injuries, and damage to property. Again, you will notice the complex crimes can be very confusing. So reading through the problem now, it says, on May 15, 2013, at around 3 a.m., Lucy, Mary, and Rafael were on board a passenger jeepney, with Rafael behind the wheel. They were traversing the highway on the southbound lane. Meanwhile, a Virgin bus driven by Kiko was traveling along the northbound lane. Kiko overtook the vehicle in front of him, which caused him to occupy the opposite lane where the jeepney was on. With the Virgin bus traveling at a high speed, Rafael tried to avoid the collision but failed. The bus hit the jeepney, which resulted in Rafael's death, serious physical injuries to Lucy and Mary, and extensive damage to the jeepney amounting to 500,000. The public prosecutor filed two informations charging Kiko for two separate offenses: reckless imprudence resulting in serious physical injuries for the injuries suffered by the passengers, and reckless imprudence resulting in homicide and damage to property for Rafael's death and the damage to jeepney. Is the public prosecutor correct? Explain briefly. No, the prosecutor is not correct. The offense is the complex crime of reckless imprudence, yung criminal negligence. Nag-iisa lang yun. Yung tumawid siya sa opposite lane at hindi niya nakuhang bumalik, no? Resulting to homicide. Yun. Because tumawid siyang ganun, no? Nandun sa wrong lane, nakamatay siya, si Rafael. Nakasakit siya, serious physical injuries doon sa dalawa, no? And that the jeepney was damaged. In other words, one single act brought about three offenses. No? So it becomes a complex crime. The single act of reckless imprudence resulted into the felonies of Rafael's death, the serious physical injuries of Lucy and Mary, and the damage to the passenger jeepney. The filing and possible conviction in the two separate offenses can amount to double jeopardy. Kasi pag nasintensyahan siya sa unang reckless imprudence, the same reckless imprudence would lead to the second case. So magkakaroon ng double jeopardy. So dapat yung mga result dito isama na ron, and therefore there will be only one complex crime with a few components. No? Yun, may homicide, dalawang serious physical injuries, and damage to property. But one main what we call this offense, which is the reckless imprudence or the criminal negligence. That essentially completes that long story on 8 problems in that bar examination involving felonies in the revised penal code. We are now ready, naka-10 na tayo, and there are only how many problems, no? There's 3, 4, 5, no? 15 lang. So kung naka-10 na, naka 2/3 na tayo. So let's go to chastity and child abuse. Here, the Child Abuse and Lascivious Act with Child's Consent. Yan. Ito yung sinasabi ko sa inyo where my original answer was the Madam X was not guilty of any offense kasi merong consent, no? Pero I had to take back that position after reading Justice Peralta's People versus Tulagan case. No? Maikli lang yun hindi naman yun ang main event. Pero through Justice Peralta, in-expand nila yung concept ng rape at sexual assault. No? And therefore, it's almost like a new reading of the revised penal and criminal law. So going to problem number 9 in the bar exams, it reads, Madam X, with the promise of money and without the use of force, intimidation, or threat, enticed Sia, a 15-year-old, to engage in oral sex by allowing Madam X to lick Sia's vagina. Sia consented because she needed the money. What crime, if any, was committed by Madam X? Explain briefly. 5 points. Madam X is liable for the crime of lascivious conduct. Offender X, that is her, committed the lascivious conduct of licking Sia's vagina in an act of one exploited in prostitution, contrary to the law on special protection of children against abuse, exploitation, and discrimination. And that is taken from Section 5, Paragraph B Article 3 of Republic Act 7610, Special Protection of Children against Abuse, Exploitation, and Discrimination. I included it here so those who are interested to go through it, either can read this or can proceed immediately to Republic Act 7610 and go to Section 5 and Paragraph B. Again, this is the case of People versus Tulagan, a March 12, 2019 case. Okay. So, ito 15 years old. No? Just a side comment. Recently, before, at the time this case was happening, the cut-off point for giving consent is 12 years old. So, if a girl sexual intercourse and she is not 12 years old, automatically the offense committed by the sexual partner is statutory rape. But if that particular girl is over 12 but below 18, and there was money or there was coercion, then it will be the case of lascivious act or sexual assault. Sexual assault, lascivious conduct. This is act. Of course, 18 and above with consent, wala na, no offense. But without any consent, papalo na ngayon yung normal rape or papalo na yung kaso ng the favorite baka acts of lasciviousness. Yun ang sensitivity dito. Now, before President Duterte stepped down, he approved a law that adjusted the age to give consent from 12 to 16. So ngayon, lahat ng mga reference to 12 has now increased to 16. Meaning, if the girl is now 16 or below, statutory rape. No? So yung window na dating 12, ngayon 16 na, 16 up to 18 may consent, no? Then walang offense. Pero if there is money, that's prostitution, or if there is force, that is essentially what they call this, with coercion, no? Then that would be already the acts of lasciviousness kung walang sexual intercourse. Kung meron, it will be definitely already also rape. No? Hindi statutory rape. Rape na talaga kung persahan. Okay. So that is the latest in the whole thing. 16 na ngayon instead of 12. So, ang biro nga ng mga iba, itanong mo muna, ikaw ba bata, ilang taong ka na? 12. Naku, delikado statutory rape. Medyo, yung katabi, medyo mas matanda ng konti. Ikaw, yun, katulad nito, 15. Oo. Naku, statutory rape pa rin. Dati, lusot na Payag ka ba? Dati, pag pumayag, wali ka. Oo, guwapo naman ako Dati yun, wala, no offense. Pero this time, itong 15-year-old na ito, statutory rape pa rin because pinanik sa 16 yung consensual sexual intercourse. Let us now move to problem number 2 on chastity and child abuse. This is problem number 13 in the bar examination. Joben, a school principal, called high school students Paula and Gina, both 15 years old, to the family room regarding the sexual text message circulating around the campus, which made reference to Joben's daughter. In front of teachers and some students, Joben shouted at Paul and Gina, asking them who sent the text message. Joben also threatened to sue them and said, "Siguro naiinggit kayo sa anak ko kasi maganda siya, matalino at mayaman. Sabihin nyo kasi sa mga magulang nyo, magsumikap sila para maging mayaman din kayo. Di yung tatamad-tamad." Jopen then raised her middle finger in front of Paula and Gina saying, "Mga burikak," war. Later that day, Paula and Gina narrated the incident to their parents and said that they were ashamed of going back to school. Is Joben guilty of violating Section 10A of Republic Act number 7610 for other acts of child abuse. Yung 7610 is child abuse. Our suggested answer, no, Joven did not commit child abuse to violate Section 10A of Republic Act 7610. Child abuse is the act by deeds or words to debase, degrade, or demean the intrinsic worth and dignity of a child as a human being. Wala kakakwenta-kwenta kasi bata ka lang na hindi naman sinabi yun. Joven did not have that intention to debase the worth and dignity of Paula and Gina. She was shouting at and berating them solely as an angry mother of her offended daughter. If you really evaluate her words, there was really no intention to degrade or demean them as children. She was just reacting na merong kumakalat na balita. So it was on that particular suspicion that they did something. It is not something to do with belittling them as children. So that's why there is no violation of Section 10A of Republic Act 7610, Special Protection of Children. And this was a case illustrated in the case of Escolano versus People of December 10, 2018. Relatively bago naman. So those are the two cases of the problems given in November 2022 bar involving chastity and child abuse. Nakaka-12 na tayo, no, 3 na lang, and we're done already with the coverage of criminal law. Ito, prohibited drugs, napakagandang kaso. Problem number 12 in the bar exam, and this is something to do with the testing of the paraphernalia. Reading now the problem. Sometime in 2011, while the police officers were conducting a foot patrol in connection with the report of rampant illegal activities in the area, Police Officer Pepe saw Raul inside the small shanty holding a disposable syringe. Being a police officer for almost 15 years and having previously made more than 10 arrests involving possession of drug paraphernalia, Pepe entered to the open door of Raul's shanty and arrested him. Inside the shanty, 23 pieces of disposable syringes and empty ampules were seized from Raul. Pepe immediately marked the seized items, took photographs thereof, and conducted an inventory in the presence of Raul, a barangay kagawad, a representative from the Department of Justice, and a media practitioner. The seized items were turned over to the evidence custodian who kept them in a sealed container in the police station. During the trial of Raul for the crime of illegal possession of drug paraphernalia, Police Officer Pepe, the sole witness for the prosecution, testified as narrated above, after which the prosecution rested its case. The defense did not present any evidence. If you were the judge, would you convict or acquit Raul for the crime charge? Explain briefly. Our suggested answer, as the judge, I shall acquit Raul for the prosecution's failure to establish that the syringes and empty ampules have traces of any prohibited drugs. There is no laboratory test to establish the use of said paraphernalia in prohibited drugs. The constitutional presumption of innocence with no proof beyond reasonable doubt will merit the acquittal. This was a decided case lately, December 9, 2020, involving Evelyn Abatines Cuico versus People of the Philippines. And this is consistent with the legal possession of drug paraphernalia under Republic Act 9165. So we have only one problem on prohibited drugs, and this is on prohibited paraphernalia. We now go to the crime on cybercrime. In cybercrime, what was dealt with is cyberlibel, and it was problem number 10 in the bar exams. Reading out the problem. During the 2022 national elections, Bern, posted on her Facebook page a statement that Alfredo, an incumbent mayor vying for re-election, has a pending corruption case with the Sangigan Bayan for pocketing 20 million of public funds under his custody. Charina, Byrne's friend, saw the post and commented online stating, "Bye, true yan. Alfredo is so corrupt. Marami ding binabahay yan," sugarol pa. Donabel, also Byrne's friend, reacted to Byrne's post by clicking the like button. Another person, Justine, who is a stranger to Byrne and her friends, but who claims to be a crusader for good governance, came across the said post. Finding it relevant to her advocacy and crusade, Justine shared the link of Byrne's post on her Twitter account. Who among Byrne, Charina, Donabel, and Justine, if any, are liable for the crime of cyberlibel? Itong cyberlibel, pareho rin ang libel yan. You accuse a person of any wrongful act, and publish it to the media, printed, or for example, radio or television. And this time now, yung internet. And if you are the author, then you become criminally liable. Pero kung saling pusa ka lang, I don't think you should be included there. I don't even know that you are either principal by indispensable cooperation or like itong si yung Stina. Linink lang naman. Ano ngayon kung nilink? Yung mga mo naman, hindi ka naman, there's no proof naman na maniniwala sila. Okay, so our suggested answer. Charina, si Charina, is liable for cyberlibel on her online Facebook comment of Alfredo is so corrupt. Yan. Sinabi niya, corrupt eh. Marami ding binabahayan. Again, womanizer siya. Sugarol pa, gambler. All character assassination, we may call it. Her public and malicious imputation of a crime, corrupt, and vice, binabayat siguro, dishonors Alfredo. Byrne, Donabel, and Justine posted no comment to dishonor Alfredo, with public and malicious imputation of a crime, a vice, or a defect, or any act, omission, condition, status, or circumstance. So, it is my position that they are not liable for any libel, more so cyberlibel. That is according to Republic Act 10-175, Section 4, Paragraph C, Subparagraph 4, and the Cybercrime Prevention Act of 2012. So that was what was given in the Cybercrime Act. And the final question, number 15, has to do with graft and corruption. And that is the last problem in the bar examination on grave misconduct under the procurement law. The problem reads, in 2003, the province of Davao del Sur purchased 2 vehicles for the use of the governor and vice governor respectively. The purchase requests, which were all signed by Luis, as then governor of the province, requested for the acquisition of 1 unit of Ford Ranger XLT 4x4 and 1 unit of Toyota Hilux 4x4. The procurement of the subject vehicles did not undergo competitive bidding as it was effected through direct purchase. The mode of procurement was approved by the members of the Bids and Awards Committee of the province. 2 vehicles were delivered to the provincial government, and after inspection and acceptance by the concerned officials, payments were issued to the suppliers. Subsequently, a complaint was filed by the concerned citizen before the Office of the Ombudsman Mindanao, OMB, claiming that the purchase of the provincial government violated the procurement law. The OMB, after due investigation, verified that the provincial government did not comply with the required procedure on the procurement law. Based on this finding, the OMB filed with the Sandigan Bayan an information against Luis and the members of the BAC for violation of Section 3 paragraph E of Republic Act number 3019, Procurement Law. The Sandigan Bayan found Luis and the members of the BAC guilty on the sole reason that violation of the procurement law constitutes evident bad faith and manifest partiality on the part of the accused. So yun, may violation confirmed. Pero bad faith lang daw yun, no, and partiality. Is the Sandigan Bayan correct? Our position is no. The Sandigan Bayan should have found Luis and the BAC members as having committed grave misconduct and gross neglect of duty for violating the procurement law concerning the mandated competitive public bidding. In the case of Ombudsman Mindanao versus Martel, March 1, 2017, and covered by Republic Act 9184 of the Government Procurement Reform Act, together with its implementing rules. That would be the last, the only problem given on graft and corruption, and would complete the 15 questions in criminal law. Sa mga kaibigan, I do not know whether I should give this assessment. To my mind, criminal law as a bar subject would not be easy. As you know, the mind of man can be so complicated to invent a lot of criminal offenses. To my mind, the 15 questions given were all, I guess, not easy, but any aspiring lawyer should have some fundamental knowledge to get a grade of 75 in each of the questions. And to my mind, a good student can get between 85 to 90 in that particular thing. Ang medyo bago lang ng konti yung tungkol dun sa rape, na pati ako medyo I had to revisit and withdraw for the first time. Yung guardian angel ko overnight, ginugulo ko. Sabi niya, mamaya mo, may bumanat sa'yo dyan. Buti nga, sinignan ko yung remaining cases. O meron palang decided case na nothing to do. 9 years old lang na naghabla ng statutory. Pero ginamit ni Justice Dado Peralta for purposes of and bank session yung nag-handle. So that to me is a real sabihin na natin masteral thesis or something on rape and sexual assault, and that should probably erase most of the jurisprudence except the case of si Bantayan. Na ito naman, meron palang pwede na palang consented sexual assault, consented sexual intercourse. Kung pumapayag yung babae, kahit na bata pa siya. Basta wag lang at this stage of the game, below 16. Pag below 16, statutory rape. Walang consensual sexual intercourse. So, piliin mo na. 16 to 18, busot ka na kung pumayag. Kung pumalag, patay. Rape ang lalabas. So with this, ladies and gentlemen, I'd like to thank you very much for giving me the opportunity to share with you my own thoughts about criminal law. Earlier, before Christmas, I already uploaded. The first one was my favorite subject, commercial law. The second one is labor law. Ito kasama na, in-upload ko, pero in-atras ko, and this is now the final one. The next one coming up in a little while is political law. Very interesting din. Medyo may mga nakakapwing din ng mga tanong. The bar examination, candidly, was not a giveaway. I would consider the bar examination of 2020-2021 really allowing law students to become lawyers with at least some concept of law. Ito, medyo hindi masyadong pwede yung 75 lang ang mo rito, kapasidad mo. You should have had a little more of that. Pero ganun talaga That is a discretion of whoever is the chairman. And I hope Chairman Justice Hernando would equally be aware that there is a little difference in the approach of Justice Leonen and Justice Kagiwa, in the matter of the calibration of the questions. I think Justice Leonen, to be fair, we in the dean among the deans, we were expecting the worst with Justice Leonen, but he will go down in the history as the most lenient and the most systematic of all the justices that became chairman of the bar exams. Justice Kagiwa, I looked at a number of his decided cases. Napakabibigat ng mga cases na sinulat ni Justice Kagiwa. And I saw that all across. Lumabas dito sa bar exams center. So with this, marami pong salamat mga kaibigan. I'd like to thank you very much. And we'll see each other on the next subject sa political law. And then yung remedial law, which is procedural law, which is my favorite. Yung civil law nire-reserve ko kasi candidly, may disagreement ako doon sa isa na aggressive na nagbigay ng answer. Yung tungkol doon sa question na yung mother nung bata, hindi niya sinama yung kanyang anak doon sa party na ginawa ng lola. Sabi may liability raw. So, ako tingin ko wala eh. And therefore, hinuhuli ko na lang para maganda yung aking latag na first question pa naman yun. I will be taking a position head-on opposite the position of that young lawyer who seems to be very competent in almost all of his answers. Except doon, mukha yatang nasway siya ng konti yung sentiment no, na bakit naman binastos nung daughter-in-law yung lola. Ako tingin ko, when you go strictly on the basis of the law, the sources of rights and obligations, lima lang yun eh, di ba? Law, contracts, quasi-contracts, delicts, quasi-delict. Hanapin mo sa limang yun, wala namang right yung lola eh. And that is the reason why I'd like to probably word my answer in such a way na hindi naman ako makakasakit kung sakaling I sound disagreeing with that particular lawyer. Okay? So with that, I'd like to close this particular get-together. We will see each other again on the following slide, which is political law. Thank you.